Welcome to everyone on this beautiful Tuesday afternoon. We appreciate you joining us as we do every Tuesday. Let's get right into it. Before we do, actually, I have a selfish, shameless plug here. We are going to be putting on an in-person 2.5-hour training on workplace investigations on Thursday, June 9th at the Doubletree in Syracuse. We're very excited to be returning to in-person trainings. It will be completed by myself and one of my partners, Katie Schaefer. Here are some of the topics we're going to cover. It's really soup to nuts on workplace investigations. We are also going to be offering HRCI and SHRM credit for those of you who are able to attend. If you want to register, there's a link there. There is also a link on the Schoeneck King website, and hopefully you've received an invitation in your email as well. All right, enough plugging. Let's get into where we are this week in COVID data. The COVID data remains not great. I think you can see that we've seen a little bit of leveling off in terms of numbers, new case numbers. We're still seeing an average of about 9,600 cases. That's our daily average. 14-day change, you can see not much, plus 2%, so gone up slightly, but not significantly. The number of tests completed has remained about the same. However, we are starting to see an uptick in hospitalizations, ICUs, and deaths, unfortunately. Those are trailing numbers. They typically trail the new case numbers by a little bit, so this is not surprising at all, given the increase in cases that we've seen over the last couple of months. But it's important to note here, no policy changes to date. So we've seen some additional recommendations on mask wearing, but we have not seen a return to mandatory masks or any other precautions that we've seen in the past. We'll obviously continue to monitor that for you, but for now, no policy changes. Next slide, please. As you can see, we are still primarily in the orange and red, some light orange or dark yellow, whatever you prefer. It's interesting, I didn't put on here, but if you look at the map of the United States, the only section of the United States that's really predominantly orange and red is still the Northeast, New York in particular. So we are still the hot spot, although if you look at the numbers historically over the past month, the hotspots within New York State have changed. It was primarily focused in central New York early on in this spike, but we've now seen the numbers expand into New York City, in the upstate area, including Buffalo and Western New York. So numbers aren't great. We're seeing somewhat of a leveling off, but the important message that I am delivering is currently there are no policy changes that are mandatory. Okay, with that, we are going to turn to our first presentation of the day. And here to do that is Kristen Warner. Kristen is an attorney in our Rochester office. She's going to talk to us about New York's FOIL law and some certain ways that the government avoids FOIL requests. So Kristen, welcome. Please take it away.
Thanks, Adam. Yeah, I'm going to talk about two specific exceptions that allow government agencies to withhold or redact documents instead of disclosing them in full that come up, it seems, the most often. So you can move the slide, Kathy, to ahead, I think. Yeah. So just to start off, what is FOIL? FOIL requires government agencies, this includes school districts and a lot of other entities that you wouldn't necessarily think of as governmental agencies, to enact rules and regulations governing the availability of records. There are certain records that they have to maintain by statute, and then there's the requirement to make all records available for public inspection and copying, except those that are enumerated in the statutory exceptions. And FOIL is found in the Public Officers Law, sections 84 to 90. Okay, next slide. So what are records under FOIL? it's very, very broadly defined as any information kept, held, filed, produced, or reproduced in any physical form whatsoever, and that does include electronic documents. So it does include letters and emails, text messages, personnel records, vendor data, invoices, voter rolls, and audio and video recordings of governing body meetings. So, you know, your town boards, your school board meetings, all of that. Now, some things like text messages wouldn't necessarily be held by the governmental agency themselves, because those are usually on personal phones that are covered by different service providers. Sometimes those can be tricky when you're requesting them, or when you're trying to evaluate whether a government entity even has responsive text messages if you're looking for them. So that one is a little, still kind of a gray area of the law. Okay, next slide. Okay, so there are about seven exceptions to the standard idea that access is permitted. So that would include documents and items that are exempt under other state or federal law, and documents or information contained within those documents that would constitute an unwarranted invasion of personal privacy. Those are the two I'm going to talk about today. There are other exceptions that deal with whether it's going to impair negotiations, trade secrets. That can be, those can sometimes be found in, for example, a response to an RFP. Sometimes those contain such financially sensitive information or customer lists that would be considered trade secrets and could be withheld. Something that would endanger the life or safety of a person. And then there are the interagency and intra-agency exceptions. You can go to the next slide. Those often come up as well. Those would be, you know, emails between members of an organization, as long as the information contained within is not statistical or factual or a final determination or any of the other listed items. Those can sometimes be withheld as well. And then those records compiled for law enforcement purposes, which I believe Jackie talked about last month in the webinar. So you can go to the next slide. Examples of records that may be exempt from disclosure because they're prohibited by state or federal law would be ADA or FMLA leave-related records, counseling memos, investigation notes, and warnings that are not a final determination in a disciplinary proceeding. The statute explicitly exempts APPR, so teacher evaluations, principal evaluations, those scores, data, observations are exempt from disclosure. Medical treatment records, a lot of home addresses, phone numbers, or personal email addresses, while public employees enjoy a lot less protection and privacy than you know, a non-public employee. Certain things still may be withheld under certain circumstances. However, there are situations where home addresses of private people would be disclosed, and that would be like on a voter roll or an absentee ballot application type, things like that. But under those circumstances, you can require the requester to sign an affidavit saying that they will not use the information contained within for solicitation purposes. That comes up a lot in with unions requesting information, names and addresses, and other information regarding either members that are employees that are members of union or employees that are not represented by a union. That's the context we usually see that come up in. Workers' comp records are not allowed to be disclosed. And then for people who have applied for jobs, there's certain parts of resumes that can be withheld. You know, their college GPA, their marital status, hobbies, personal references, things that don't have any impact on their ability on their job can usually be withheld under those circumstances. You can also withhold application materials for unsuccessful job candidates. So that would be an invasion of personal privacy if, you applied for a job and you didn't get it. That could impact, your current employment if they didn't know you were looking elsewhere. IEPs for school districts are also exempt from disclosure under the statute. And then, next slide. A lot of the, next one too, sorry. A lot of the things that are covered under the unwarranted invasion of personal privacy are, pretty common sense, employment, medical, credit history, like I said, personal references, and the definition itself is disclosure of information of a personal nature when disclosure would result in economic or personal hardship to the party. So you're not allowed to say, if there's emails going around about somebody having a financial hardship, that would be an unwarranted invasion of personal privacy should that be made public. So basically, this category is a fact-specific analysis, and whether it is or isn't an unwarranted invasion, there's a lot of opinions. There's a lot of advisory opinions that are helpful in determining whether you can release something or whether if you are the requester, if you're allowed to see something. But yeah, it basically, you usually have to read whatever the document is and make a determination based on the content. This category of exemptions doesn't cover usually specific categories of documents. It's more about the content. So that was the basics on those two exceptions to full disclosures. So if anybody has any questions, I'm always available by email to answer any FOIL-related issues.
Kristen, thank you so much. All right. Next up, we have Stephanie Fedorka. Stephanie has presented many times on these webinars, and she's back to talk to us today about drug and alcohol policies. A recap and tip, and I will plug Stephanie again for her excellent work on employee handbooks. She is really an expert in that field. So if you have any questions on your handbooks, please feel free to reach out to Steph. But today she's here to talk about drug and alcohol policies.
Thanks, Adam, and thanks everyone for joining us. It's great to be here with you all again this lovely Tuesday afternoon. I'll preface my few slides with saying that I think this topic could cover a full hour presentation in and of itself, so I'm going to try to keep it high level for you all, just as some reminders and some recaps of things that you should be considering if you have a drug and alcohol testing policy or a drug and alcohol policy for your workplace. If you don't have one, but you're thinking, maybe we should have one. And other things that you should keep in mind, particularly in light of the law that changed last March. If you recall, marijuana became legal, adult use, recreational use became legalized in New York last March. And with that came some changes in the New York labor law that now affect what employers can and cannot do with respect to marijuana and the workplace and off-duty conduct. So first and foremost, I think when we're thinking about drug and alcohol policies, here are some considerations, right? You always, of course, want to think about safety and what types of activities or what types of job functions are in your workplace that require this essentially these considerations for safety. Even if you're in an office setting, right, there may be some safety considerations with respect to drug and alcohol use, of course. Efficiency of operations. That, of course, also go along with if someone's using drugs or alcohol, right, there may be concerns about job performance and efficiency of your operations. In addition, other things that may be worth thinking about and knowing if you are subject to these are going to be requirements. For example, the Federal Drug-Free Workplace Act, which applies generally to federal contractors or grantees. US DOT, the Department of Transportation drug and alcohol testing regulations, frequently referred to as Part 40. There's different agencies that have slightly different requirements, or if you are subject to, for example, the Federal Motor Carrier Safety Administration requirements. Those are the CDL drivers and your safety sensitive employees under that. That's the FMCSA, but there's also aviation, the FAA, the Federal Railway Administration, the FTA, PHMSA, which is the pipeline and hazardous materials, or the U.S. Coast Guard has their own requirements as well for commercial watercrafts. So knowing whether or not you're subject to the US DOT drug and alcohol testing regulations, those are very specific as well and have their own nuanced policy requirements, program requirements, training requirements, et cetera. And then the Drug-Free Schools and Communities or Campuses Act, which also contain each one of those requirements might have slightly different requirements as far as what needs to be in your policy, when you have to distribute your policy, if there's any posting requirements, training obligations. So it's important to know whether or not you're subject to one of these several requirements that might require you to have something more complex or comprehensive than a regular, everyday, if you will, drug and alcohol policy. So understand what requirements apply to you and understand what the requirements actually mean or actually require. I say this because I think there's a common misconception that, for example, the drug-free workplace policy requires testing. That's not true. The drug-free workplace policy requires that you maintain a good faith effort and a reasonable effort to maintain a drug-free workplace. And there's certain language you have to have in your policy, but it doesn't actually require testing. Compare, of course, the US DOT drug testing policy or regulations, which do actually require testing at very specific times. So understand what the policy or what the requirements actually mean to you and mean to your workplace, what actions must actually be taken. Again, I reference the US DOT regulations, which if someone tests positive, for example, in one of those required testing times, it requires that you remove that person from the safety sensitive function. But strangely enough, and I think another common misconception is, does the law require, do the regulations require that we terminate them? It doesn't actually require that. Of course, employers can work on modifying their policies and tailoring their policies, but it's important, I think, to distinguish and to know what's actually required by the law or the regulations that you have to follow, and what you want to do in your workplace and what you should do, and if there's any barriers to that based on maybe some conflicting laws that we'll talk about in a little bit. Right? Do you need a written policy? Does the policy need to have specific information? Which, as I indicated on the prior slide, those different requirements do have very specific policy requirements and content that has to be included in your policies. Several of them require training. Is there other information that must be provided? So understanding those types of things and any other administrative obligations that might come along in part and parcel with your alcohol and drug policies and enforcing those. For example, the DOT, again, the FMCSA clearinghouse has reporting, and you have to check it at certain points, or reporting drug convictions under the Federal Drug-Free Workplace Act. Understand the difference between a zero tolerance policy and saying that you won't tolerate certain behavior, right? A zero tolerance has the connotation that there is no discretion, there is no wiggle room. If there's a violation, termination is the answer. And understanding, again, what might work for your workplace. A few weeks ago when I was talking about handbooks, I said that mentioned the zero tolerance again as an important consideration for employers, because do you want certain discretion in certain circumstances, perhaps? Drug and alcohol testing. I think some employers, if you're not subject to the DOT drug testing requirements or drug testing policy requirements, do you want to have drug testing? Is there a reason you want to have drug testing? What kinds of drug testing are you going to do? And that's important to address in your policy, or a reservation of rights to drug test. If there's something, you might hear the terms reasonable suspicion. If you have reasonable suspicion to believe that someone is under the influence or impairment of drugs. So including if you do drug testing, or if you want to do drug testing or reserve the right to, that should be addressed in your policy. I think it's important too to be mindful of disability discrimination, because alcohol or substance abuse problems and recovery could be disabilities covered under a federal or state law. Employees who take prescription medications or other over-the-counter medications or use medical marijuana may also be protected. So I think it's important when you're drafting policies to be mindful if you have certain information in there about reasonable accommodations. And it's important, I think, in those particular cases to work with counsel to make sure that you are not crossing any lines or putting yourself at any legal risk by virtue of what's in your actual alcohol and drug policy or from enforcement of your policy. Marijuana, as you likely recall, March 31st of 2021, the state passed the Marijuana Regulation and Taxation Act, which essentially legalized recreational use of marijuana, among other things. And most importantly, I think for our discussion today is it changed and added a new provision to New York Labor Law Section 201D and now protects lawful off-duty use, which we'll talk about. It's also important, I think, to mention that prior to that, New York City had passed a law in 2020 that prohibited drug testing for marijuana or THC as a condition of employment. And I will send links to both of those guidance documents after I am done speaking on these slides, so you can have that for reference. But there are several exceptions under the New York City law that are included in the guidance, but I think those are important, particularly if you are going to drug test or if you have to drug test. So quickly, I won't read every word off the slide, but under New York Labor Law Section 201D as a recap, remember employers are generally prohibited from discriminating against employees because of the employee's off-duty or lawful off-duty use of cannabis. So that means that it's not being used in the workplace during working hours or while the employee is using employer's equipment or property. Note that this doesn't mean that you can't have a policy that prohibits marijuana use, right? You just can't generally prohibit lawful off-duty use. And you generally can't take action based on that lawful off-duty use. You can still, as an employer, take action or prohibit conduct as might be required by state or federal law. So if you are subject to those DOT regulations, if you have to take action based on those regulations or those laws or ordinances or regulations or mandates, then that's still permissible. Where an employer would lose federal contract or federal funding, where an employer would otherwise violate the federal law. I think it's, we get a question a lot, well, if marijuana is still illegal under the federal law, is that a loophole? And I don't think that's what this is construed to create here. I don't think that's, this provision would allow for employers to still prohibit lawful off-duty use. I think that would make no sense based on the law that's passed in New York State. But if you would otherwise violate a federal law or those other types of federal requirements or contracting requirements, right? Where an employee manifests articulable symptoms of impairment while working that decrease or lessen the employee's performance or their tasks or duties, or where the employee manifests articulable symptoms of impairment while working that interfere with an employer's obligation to provide a safe and healthy workplace. So in October of 2021, the Department of Labor issued guidance, and it was helpful to some degree because it made clear a few things. One of the biggest things is that testing cannot be a basis for an employer's conclusion that the employee was impaired by cannabis. I think that's in large part because the testing that we have for cannabis right now can it's not accurate of determining whether someone is currently impaired, right? If someone smokes marijuana on Friday afternoon and is drug tested the following Tuesday, they're likely not impaired, but they are likely going to test positive for marijuana or cannabis. So that was clear in the guidance. In addition, employers cannot test for cannabis unless otherwise required to do so by another federal or state law or as otherwise permitted by New York Labor Law Section 201D, this subsection 4A, which generally I think our understanding and current interpretation of that is where someone does exhibit articulable symptoms and you believe them to be under the influence at that time. You could test them at that time, although that test those test results alone are not going to be enough to rely on in order to take some sort of adverse action against that employee. So properly documenting those articulable symptoms is going to be critical. In other words, pre-employment and random testing for marijuana is presumably no longer lawful under New York, again, unless it's otherwise required by federal or state law. The second important note, I think, and the big takeaway from the guidance was this articulable symptoms, right? There's no dispositive or complete list of what types of things or behaviors are going to be considered articulable symptoms, but they must be objectively observable indications that the employee's performance or duties are decreased or lessened. One of the questions or FAQs as part of the guidance makes clear that the smell of cannabis or odor of marijuana alone is not going to be its own articulable symptom. So I think the recommendation here is to make sure that your supervisors are trained, that folks are trained as to what are articulable symptoms, and have some sort of process and work with counsel about what types of documentation should be prepared, I think, in real time or as close to real time if there are concerns about someone coming to work impaired or under the influence of marijuana. So that's all you have for me, but if you have any questions or concerns, feel free to reach out and I will send the links to those 2 guidance documents in the chat.
Stephanie, thank you so much. All right, moving along to our next topic. I promised at the last webinar that Lou DiLorenzo and Jeff Kill would be back because they got pushed out of the last webinar due to time constraints, but here they are, and they're going to actually be talking about a really important topic that impacts all employers in New York State. So Jeff, Lou, welcome back. The floor is yours.
Thank you, Adam. Good morning and good afternoon, everybody. Lou and I are going to talk about employment at will today, and it is an interesting topic. We cover it in the book. You'll find it in chapter 2, but to understand it fully, you also have to read chapters 4, 5, 8, 11, and 12. And having shamelessly plugged the book, I just want to remind you, we don't make any money off this. It's a labor of love. Adam and Kathy can tell you how to buy it. What is employment at will? Employment at will is a doctrine which says in an employment at will state, an employee can be discharged for any reason or for no reason, and with any sort of prior process or no sort of prior process. And New York is an employment at will state, except when it's not. And a lot of the time, it's not. Time permitting, we'll get into the reasons why it's not, but I can state it very generally. An employee can be terminated for any reason or no reason or with or without process unless it is in violation of an individual employment contract, which might either give someone a promise of employment for a fixed period of time or a promise of employment with no termination except for just cause. An employee is an employee at will unless he or she is covered by a collective bargaining agreement, which 99 times out of 100 will have some sort of provisions governing just cause for termination and processes for termination. And an employee is an employee at will, except if discharge would violate a federal or state statute, of which there are many. And we will get into that list later. Before I turn the floor over to Lou for his thoughts on it, I do want to pick up on Stephanie's area of expertise, which is employee handbooks. And the question is, if you want to be an employer at will, is it in your interest to have something in the employee handbook and or an offer letter making it clear that employment is at will? And I think the short answer to that is yes, it is in an employer's interest to do so. The interesting thing I encountered in my practice, which was primarily for not-for-profit and educational institutions, is that the traditional formula doesn't go down very well with everyone. Traditionally, an offer letter or an employee handbook, which has an employment at will provision, says in words or substance, your employment is at will, meaning that your employment can be terminated at any time with or without cause. And I've had employers turn to me and say, Jeff, that's nice, but isn't that awfully harsh? This is not the kind of and working environment we want to project to our staff. I came up with another formulation. I'm certainly open to other suggestions. Many of my employee handbooks have said XYZ company is an employment at will employer. This means that you may end your employment with us at any time and for any or no reason, and we reserve the same prerogative. Lou, I'll turn this over to you and start by asking, can you gag that down as an alternative?
Yeah, thanks, Jeff. So I agree with Jeff that this concept of employment at will, which a lot of people, look over and say, okay, New York's an employment at will state, but it's very tied to some of the issues that Stephanie talks about with handbooks and that Jeff has been talking about, offer letters and so on. There's a number of ways you can do what Jeff suggested, and he's right. The short answer is you should do something about it. Some of the ways you can do it. So for example, let's say that you have you're in an industry with high density unionization and you're putting a handbook together and you're a little bit afraid to say, we're employed at will, we're an employment at will employer, which means you can quit anytime, we can fire you anytime, with or without cause, with or without notice. And it's a ripe opportunity for a union to come in if you're interested in remaining union free. Ripe opportunity for a union to come in and say, look, this handbook, isn't worth the paper that it's written on, because you can be employed at will, and it all goes up in smoke. So sometimes I've seen clients, and on behalf of clients, we've been imaginative in describing the purpose of the handbook, which truthfully is a document that's dynamic, that needs to change from time to time. To stay accurate and current with changes in the law, changes in our culture, changes in our needs. We couldn't have a better example of changes in needs in the last 3 years, going into a pandemic, during a pandemic, and coming out of a pandemic. So sometimes we just reserve the right to make changes whenever necessary, whenever management deems necessary. Now that's been held by the New York courts to destroy any contractual implications of that handbook, because one party has unilaterally reserved the right, or has reserved the unilateral right to change it with or without notice. Again, depending on how you write it, a union can come in and say, hey, it's not the kind of contract you get with us if you sign up and pay union dues. But it's a little bit more explanatory as to why we need to make those changes, because it is a dynamic workforce and a workplace, and we don't want it to change. But in terms of employment at will, there's not a lot of states left that are employment at will. And if we had a target up and showed holes in the doctrine, if the target was, or background was, employment at will, and we put in holes for all the exceptions in New York, it would be all the discrimination statutes. It would be the workers' comp statute that says you can't discriminate against people or retaliate against people because they filed a comp claim or disability claim. There are almost enough exceptions to swallow the rule. But the rule is still not swallowed. It is the basic rule. Somebody's employed at will, and it's important for them to show that there's been a statutory violation or a constitutional impermissible purpose for which the person was fired, or some kind of a contract, express or implied. The express or implied one is a little bit more tricky. I've seen people make mistakes in the express or implied situation. For example, people will take a handbook or a policy. They will describe in detail their progressive discipline policy. They will describe in excruciating detail how they're going to investigate sexual harassment complaints. You're going to give a notice of the charges. We will follow due process protections. When you offer those things up, you're a private employer, and on your own, you've offered up incredibly detailed provisions. There's always that risk that you're going to get caught up, you're going to get caught up in your own underwear, and you're going to have a problem. You're not going to follow some specific procedure that you've imposed on yourself without general language. How can that be a problem? Well, There's an Article 78 in our civil practice law and rules that applies to all public and private bodies. And what it says where there's a violation is where you refuse to follow the terms of one of your policies. I'll give you an example. A college, Long Island, drafts a sexual harassment complaint provision. And it says that there will be a hearing procedure. And at the end of that hearing, the panel can recommend sanctions if they find someone guilty of a violation of the sexual harassment policy. So a non-faculty member of pretty high-level executive was accused of sexual harassment. He said, she said type of case. The panel is concerned about making a finding without, direct concrete evidence, but they do believe that this executive did some things inappropriately. So instead of making a determination that he violated the sexual harassment policy, they issued a decision that said, we believe this administrative official acted inappropriately and should be disciplined. Not that we found he engaged in sexual harassment in violation of the policy, he acted inappropriately. The president, as was provided for in the policy, took that decision, recommended immediate termination. The gentleman was terminated. He sued in court under Article 78, saying you didn't follow your own policies. Your policy says that body is authorized to recommend termination if they find me guilty of sexual harassment. They didn't. They found me guilty of inappropriate conduct. He was reinstated with back pay because they didn't follow these policies. Now, if you're non-union and you're not negotiating a contract or negotiating policies, we draft these ourselves. Maybe in today's work environment, we engage some employees to participate in that activity or run some things by supervisors and employees to help them shape what the workplace looks like. But shame on us if we're writing our own policies and we're making them so specific, so detailed, so comprehensive that it becomes difficult for us ourselves to make sure we follow them, and we lose the advantage of the employment at will doctrine. We've restricted our ability to act the way it permits. So you want to make sure you're careful with how you draft the policies. Stephanie brought to mind, in terms of talking about being careful with policies, Stephanie brought to mind when she mentioned zero tolerance and no tolerance. So I've stopped using that term zero tolerance. And the reason I stopped using it is I understood it always to mean I don't tolerate this. Zero tolerance means you can't do it. Doesn't mean you'll be fired if you do it. It just means you can't do it. And I'll decide, or the management will decide, on what the appropriate penalty is if you violate the policy, because we don't have any tolerance for this. So what's happened with that policy? First of all, people argue that what it means is somebody's supposed to be automatically terminated because I said I have zero tolerance for this. It's not what it said, but that's what people think. The real impact of having such a policy is the experts have been testifying that if you have zero tolerance in your handbook or your policy, many, I'll use the term because this is what the finding is, many women, although I'm sure it applies to others, have been afraid to file sexual harassment complaints because the policy says zero tolerance and they don't want the person terminated that they're filing against. They're either concerned, they may even like the person, except they have this one defect of engaging in sexually harassing conduct or discriminatory conduct of some kind. Or they're concerned that if this person is so well liked, so charismatic, so important to the business, if I file against them and they get fired, all their friends and other people, maybe even my friends, will retaliate against me because I'm the cause of that particular person being fired. So the statistics and the experts indicate that people have been reluctant to file because they understand zero tolerance to mean automatic termination if somebody has violated the policy. So think about how you want to describe that. Whether you explain what zero tolerance is, doesn't mean the person's going to be fired. It means we don't tolerate it, and somebody might be verbally warned, counseled, suspended, terminated, sent to, Bill Clinton rehab school to correct the problem. Whatever the issue is, in some form of discipline less than termination, but be careful with that language. Again, It points to the fact that we have to be careful with the language of the policies in the handbooks.
Lou, I think that's an important point, and what it really stresses is that your employee handbook is not a laundry list put together from multiple sources of stuff that sounds good to put in an employment handbook. It really has to be drafted and read as an integrated whole. Now, I'll give you a ready example of it. If an employee handbook talks about probationary periods, well, what does the completion of a probationary period imply? It implies permanent status. And some handbooks actually say when you've completed your probationary period, you're going to get permanent status. Well, now you fired somebody on permanent status for any reason or no reason. It sounds like your employment handbook was meaningless, which you don't want it to be, or that you restricted your ability to terminate that employee. So, for example, we have suggested that when someone completes a probationary period, the following status should be described as regular or non-probationary, but not permanent. And you really do want to preserve the fact that your employee handbook is written as a whole. When we talked about discipline a few weeks ago, and you may very well want a progressive discipline policy in your handbook, you absolutely want the additional phrase in there that says progressive discipline will not apply in all cases. And in appropriate instances, termination will be the first disciplinary penalty imposed, because otherwise you will be, as happened with Guy Fawkes Day in England, hoist by your own petard.
Right.
You also need to worry to some extent about the representations that are made to an employee when he or she begins work. There is a New York Court of Appeals case called Wiener, which has been narrowed. But basically there, the employee said, look, I got fired and they fired me saying I was an employee at will. But they talked me into leaving my old job by saying that there's a firm policy at this employer of not terminating people without just cause. And when I signed the job application says that my employment is subject to the employee's personnel policies and procedures. The employee handbook said no one will be terminated without just cause. Well, what our New York State Court of Appeals decided in Wiener was, if all of that is true, you may just have a case for breach of contract.
Yes, one of the important lessons of Wiener, Jeff, as you know, is that in that case, the employee was given the handbook before they accepted employment.
Correct.
Testified that I relied on that language in accepting and keeping the job. So one of the lessons here is whatever your policies are, really you should try to have a practice, if possible, of not giving it to applicants until after they start employment. We've had several cases dismissed where we were able to prove that they did not see the handbook before they started, or a wayward policy. So they can't say they relied on it in accepting the job, and the case has been dismissed on that basis. So hold on to it. A lot of people ask for them ahead of time. You got a candidate you're trying to recruit. That's one thing, but to routinely give them out as part of your process to finalists or something, I'd hold on to them to avoid that issue.
Lou, we're tight on time. Let me close with the parade of horribles, which you can't do even if you are an employment at will employer. You cannot terminate somebody for a discriminatory reason. And if you look in Chapter 11 of the book, there are a broad range of protections against discrimination, which aren't just the traditional ones. They include things like domestic violence victim status and genetic predispositions. You can't fire someone in retaliation for engaging in an activity which is protected by retaliation procedures. You cannot fire somebody for taking time off, which you are legally required to give. And that can be jury duty, voting leave, military service leave, sick and safe time leave, and you'll find all that stuff in Chapter 4. As Lou mentioned, filing for workers' compensation benefits is protected. You can't fire someone for doing that. And to pick up on what Stephanie said about Labor Law Section 201D, it's a very broad section. You cannot fire somebody for engaging in any legal off-premises activities, politics, wearing an ugly green propeller beanie, recreational activities, riding a motorcycle. So bear in mind, if you don't like that green propeller beanie, only fire the employee for wearing it at work, because off-premises, it's a protected activity.
Let me add one more little known one in New York that some people make mistakes with, which is if you hire someone for a definite period of time. Sally's gone out on pregnancy leave, and I send somebody a letter that says, we're hiring you to be a temporary employee who will work until June 1st or September 1st. If that's all I say in that offer, you could be hiring a temporary employee who you can only fire if you have just cause. The law implies just cause if someone has been hired with nothing more said for a definite period of time. So when you hire somebody for a definite period of time, you want to be careful that you reserve that right.
Well,
And we're out of our definite period of time, so have a great week, everyone.
Lou and Jeff, that is really great advice. I can't tell you how many times I have seen an employer say, I fired this person, but New York's an at-will state, so I'm good, right? And the answer is very clearly no, not necessarily. So thank you so much. Those are great tips. Great to see everyone again this week. If you have questions, topics you want us to cover, please fill out the survey and let us know, and we will absolutely do that. So thank you again. Great to see you. We'll see you again next Tuesday.
Take care, everyone.